So I see we have participants arriving in, and while they continue to connect, let me introduce myself and bring you greetings to this webinar jointly arranged by the Commonwealth Parliamentary Association and the Commonwealth Lawyers Association in a unique collaboration between our two associations, each of whom are accredited organisations to the Commonwealth Secretariat. You are very welcome to this webinar, and let me say that my name is Brian Spears and I am the President of the Commonwealth Lawyers Association. With me on screen is Emily Davis with a very fetching backdrop of the CPA. Say hello, Emily, and I'll bring you in for proper comment in a moment, but let's hear you.
Thanks very much, Brian. Good afternoon, everyone. My name is Emily Davies from the Commonwealth Parliamentary Association, and I look forward to the discussions that we're going to be having today.
Excellent. Well, let me just set out what might be termed some ground rules. This is being recorded, and it also is apparently live streaming on YouTube. We know that you can see us, but we cannot see you, but we do know that there's over 100 participants on the Zoom video that we're on, and there might be others out there on YouTube. So that's very gratifying that there's been such interest in this topic. Can I pay tribute to Stephen Twigg, the Secretary General of the Commonwealth Parliamentary Association, and to Bridget Watson, the Secretary General of the Commonwealth Lawyers, and their respective assistants for the hard work in making the arrangements for today and assembling our panel. Can I also say that one of our panelists at a very last minute has encountered an emergency in the business of the Parliament of the Maldives, and as speaker he will not be able to join us. That was the Honourable Mohammed Nasheed. That said, we have a great panel that I look forward to introducing, and I very much look forward to hearing what they all have got to say. The CLA, my organisation, is an organisation of really practicing lawyers, bar associations and law societies in the Commonwealth. Our interest is in upholding the rule of law, which has many aspects, some of which are relevant to our theme today: access to justice, independence of the legal profession, independence of the judiciary, and the separation of powers. And the CPA, the CLA, the Commonwealth Legal Education Association, and the Magistrates and Judges Association combined some time ago to create the Latimer House Principles, the Latimer House Guidelines on the separation of powers, and those principles were adopted in Abuja, Nigeria in 2003. I am sure that some of the wisdom in those principles will come through in our presentations today. The CLA holds a conference every other year, and we're still hoping for an in-person conference in the Bahamas in September on the theme of sustainable justice. And that again is worth mentioning for today, because justice needs to be sustained by the absence of autocracy and the presence of accountability. And I hope that our speakers and our questions will bring out some comment on those important areas. If you have a question, you can place this in the YouTube channel comments, but you can also place your questions in the Q&A or indeed the chat box within this Zoom webinar. And those will be monitored and fed back to Emily, who will have to have her wits about her to summarize and distill any comments or questions. So this question of lawyers and parliamentarians and the rule of law can bring some of our elected representatives across the Commonwealth into conflict with lawyers. Lawyers, we think we're doing our job in holding Parliament and the executive to account. The executive say, in effect, butt out. We were elected, we have got a programme to govern, and the regular interference of legal challenges gets in the way of our programme for government. In the UK, allegedly the mother of parliaments, we had a very remarkable headline in one of our newspapers back in November 2016, when three very eminent judges, including the then Lord Chief Justice and Master of the Rolls, found that the government could not simply exit the European Union without the consent of Parliament. And one of our national newspapers pictured the three judges below a headline, "Enemies of the People." And that was very stark, highly criticised, and I think things have greatly improved since then, but nonetheless, it demonstrates the tension that can exist when lawyers challenge, when judges make a decision based upon the law, and that somehow collides with the wish of the executive. Not unique to the United Kingdom by any stretch, but nonetheless, I give that as an illustration and to whet our appetite for our panel. And we're going to lead off in a moment with a South African friend, former judge of the Constitutional Court, Judge Zak Yacoob, who I will introduce in a moment. We then have the President of the Senate of Antigua and Barbuda, and we look forward, Senator, to your comments after Judge Yacoob. And then I will introduce a practitioner from Oyo State in Nigeria, Olusegun Abimbola, and we look forward to what you have to say. And I will provide our audience with one or two additional comments as we turn to the speakers. Our theme is lawyers, parliamentarians, and the rule of law. And it is a tremendous delight to introduce someone who I am pleased to call a bit of an old friend, Judge Yacoob. I have spent some time with you in Botswana and in Zambia when we attended conferences together, and I feel we hit it off, and I've greatly enjoyed being in your company, and it's a very great honor and pleasure to introduce you now. You might want to prepare for speaking by coming off mute, Judge, just at present. And Zak Yacoob is well known in South Africa, a former judge of the Constitutional Court, appointed in 1998 by Nelson Mandela. Very distinguished in his academic learning and in his appreciation of the rule of law and the role of the judiciary. I simply am delighted that you have agreed to take part, Judge, and could you share your comments on this theme for approximately the next 10 minutes. Thank you.
Thank you very, very much. It is an absolute honor to be present here, and I look forward to addressing what is a very relevant topic, a controversial topic, but something which all of us have to come to grip with. It is very important to start by emphasizing that lawyers, parliamentarians, and the courts are all accountable. And it is this accountability which is probably the hallmark of democracy as we understand it. I somewhat adventurously wish to address 4 topics. The first concerns the issue of the separation of powers and the rule of law. In its classical form, separation of powers represents a delimitation of powers between the judiciary, the executive, and the legislature. And typically, the executive is supposed to administer the law, Parliament is supposed to pass it, and the courts are supposed to interpret it. But this is not the full story for a number of reasons. because the separation of powers is not a static concept. It is dynamic. It changes from time to time. It changes in context, and it changes as time goes on. And secondly, the problem is that the interpretation of the law is quite a complex business. So that the interpretation of the law by the judiciary could quite often give rise to a degree of lawmaking which causes difficult problems. The other difficulty is that the separation of powers, which I would say somewhat controversially, England is the mother of, differs now from place to place and from constitution to constitution. So there is no static separation of powers. The separation of powers and the way in which it is applied depends on the provisions of a particular legal instrument in a particular country, and sadly, as far as parliamentarians are concerned, also depends on the judgments of courts from time to time by which judges themselves are bound, and we need to bear that in mind. But the separation of powers is important, although it differs from time to time, and it is precisely because it is a dynamic concept that it is vital for the achievement of the protection of the rule of law. But complicating all this leads me to the second topic, which is opinion and discipline. In determining the separation of powers and who has precisely which power, the judiciary ultimately makes the determination. But in making that determination, courts are not repairing motor cars. They are giving judgments in which there would be all kinds of differences of opinion, so that there would always be a difference of opinion, not only between the executive, parliamentarians, and judges about where the line should be drawn, because obviously it is not a fixed line, but also a difference of opinion between lawyers amongst themselves, and a difference of opinion amongst judges amongst themselves too. And therefore, what do we do? The way to manage differences of opinion in relation to separation of powers, in my view, is discipline. Discipline of all parties concerned in the process. That discipline involves the acceptance of what applies in a particular country. For example, in South Africa, the highest court in the land is the Constitutional Court. It consists of 11 judges. The majority of the judges of the Constitutional Court declare in any particular judgment an opinion which is binding on the whole of the country. And it is discipline that is required, quite apart from our right to criticize those decisions, which all of us have, to accept that those decisions of the highest legal authority are indeed correct. And quite often, even judges have to exercise that discipline, because the exercise of that discipline means that when I was a judge and a judgment was given today with which I fundamentally disagreed and filed a minority judgment, in a judgment that I write tomorrow, I've got to accept that that judgment is correct. So discipline to manage difference of opinion is vital, because we are never going to be the same in terms of our opinions. The other complicating issue is that everybody is unhappy about losing cases. I have never seen a loser of a case who is happy. And therefore, different ways are found to express the losses. Sometimes courts are criticized, sometimes approaches are criticized, and it becomes difficult when court decisions offend many parties who are the losers, in which case courts become the butt of things. So the discipline involved in relation to courts and in relation to management also involves managing public opinion. And that takes me to the third element of our discussion, which is populism and politics. People are elected by the parliamentarians are elected by the majority of people. Ultimately, it is the parliamentarians who are accountable to the people. Judges, on the other hand, are also appointed in terms of a legitimate process, which not directly, but indirectly is the function of the lawmakers. And therefore, judges cannot be said to be entirely and completely unrepresentative of the people. The problem is that we understand that parliamentarians and quite often government have to take into account the views of the people, and they have to be to a degree opportunistic in terms of being slavish to the wills of the people in the way in which they decide cases, in the way in which they respond. Judges and lawyers, on the other hand, are different. We cannot ignore the opinion of the people. On the other hand, the opinion of people, populism, cannot be our total guide. And in a sense, detractors from the rule of law have taken to rely on populist approaches. And those populist approaches in England, for example, would be that judges are, and if I don't remember it correctly, are traitors to the people. In South Africa, it is the same trend of populism, because all judges who take a particular view which opposes a particular political view are now said to be supporters of what is called white monopoly capital and anti-black and anti-African, even if they are African judges. So populism is a weapon we all have to be very careful of, understanding though that political people need to rely on human beings. And therefore, I would go a little further and say that the discipline that applies to lawyers and judges also applies to parliamentarians, and I will come back to that. And now I come to the fourth topic, which is corruption and COVID in that context. COVID-19 has come into the country and lawyers have become involved. There have been a whole range of regulations, initially not passed by Parliament, not even approved by Parliament because of the urgency of the situation, a little different from Brexit, but regulations have to be lawful in our country. The regulations have to be rational in our country. Some regulations have been set aside, others have seen the course of day and have worked themselves through, but we have done very, very well. Speaking personally, I have never understood the total closure of businesses except initially. I have never understood the closure of alcohol outlets because as far as I'm concerned, as long as there is absolute total control, masking, discipline, distancing, and you limit the times of alcoholic consumption in public and ensure that nobody consumes alcohol in public after a particular time to limit motor accidents and so on, that should do it. But the corruption in our country has also been plagued by corruption. Corruption on the basis that urgent contracts have to be meted out in relation to corruption, and therefore these contracts have to be resolved, and many of these contracts have to be set aside. We've had many, many inquiries in relation to corruption, and the important byproduct of COVID-19 has been that many corrupt people have been caught. Now, so COVID-19 has been good in our country, but it has taught us a new way. It has taught us that courts too have their role. It has taught us that lawyers too have their role. But the issue of discipline is very clear, because the guiding principle is the best understanding by which COVID-19 is prevented, and that has guided the work of lawyers and judges in the country. And therefore that enables us to understand that it's not law or politics in isolation. The guiding principle is the sustainment of democracy and the improvement of the quality of lives of all people. And finally then, in that context, what is the appropriate role of parliamentarians and lawyers in relation to these matters? in the context of differences of opinion and in the context of all the complicated matters which I have talked about. I would suggest, controversially again, that parliamentarians must be, and lawyers and judges, all have to be careful and disciplined. On the understanding that everybody would disagree with the viewpoints expressed by everybody else, and on the understanding that differences of opinion are legitimate, it is extremely important for all of us to challenge things and make statements about improper and unlawful or wrongful conduct by any of the branches of government. And I concede that even judges can overstep the mark. But before we criticize, excuse me, this must not be done for populist purposes. It must not be done for the purpose of ensuring that people get more support. It must not be done to support populism. If all of us are guided by the discipline that the well-being of human beings in our country is prominent, and if we understand that there be differences of opinion, and if we begin to understand jointly, parliamentarians and lawyers, that all of us are beginning to ensure executive accountability, that accountability doesn't necessarily mean bowing to the whims of people, whatever those whims might be, and that each of us are doing our work. And this kind of meeting where we gather to talk about things and work out how we do our work, and we understand each other in terms of our role in the fulfillment of democracy, true democracy, and the improvement of the quality of lives of our people, honest and uncorrupt government, I would think that we have done very, very well. But it is a long road, and what we hear here today and what we are doing here today is just one step in the process of achieving that long road. Thank you very much.
Fantastic, Judge Zach. Thank you so much for sharing those thoughts. It's always nice when you get vaguely familiar themes, but just condensed into a short period of time, and it all sort of clicks and makes sense. I will certainly take away from what you have said the fact that lawyers, judges, and parliamentarians are all accountable, that we need to not fear difference of opinion, but accommodate it, and this need for discipline. Those are great insights, summarized perfectly, and thank you so much. If you wish to return to mute, that might prevent any sort of background interference as I move to our next speaker, but really saying on behalf of everybody, thank you so much for those remarks to date. You're back off mute again, that's you. Our next speaker is the Honourable Senator Alincia Williams-Grant, who is President of the Senate of Antigua and Barbuda. Speaking from Antigua in your early morning, Senator, and we very much appreciate you joining us at this time. The Senator is a law graduate, was and still is a lawyer, having practiced as in-house counsel to the East Caribbean Bank, the Antigua Commercial Bank, and has been principal attorney in her law firm of Williams-Grant since 2008. In 2014, Senator Williams-Grant was appointed to the Senate and elected President of the Senate in Antigua and Barbuda, and was re-elected after the elections in 2018 and remains in the position of President of the Senate of Antigua and Barbuda. So we're very intrigued to have you here. We're pleased that you've joined us, Senator, and we look forward to your reflections on our theme for today of lawyers, parliamentarians, and the rule of law. Over to you.
Thank you very much, Brian, and good day to everyone. I'm very grateful for the opportunity to contribute to this discussion today. I wish to take this time to say thank you for the invitation to the Secretary General, and a hearty congratulations to the organizing team for the effort in facilitating this conversation today. Please permit me at this time also to extend on behalf of the Parliament of Antigua and Barbuda and my regional colleagues in the region, in the Caribbean, sincerest condolences to the family, the Parliament, and the people of Cameroon on the passing of Vice President of the National Assembly and former chair of the CPA Executive Committee, Honorable Lafika Amelia. We pray for your comfort and strength, and please know that we stand prayerfully in solidarity with you as you grieve her passing at this time and remember her legacy. I think for me, her passing has underscored that we're all trying to make a difference on this earth while we are duty bound to navigate on our respective journeys. And today is part of the process of navigation that I've faced, even probably before 2014, because this topic of separation of powers is one of my favorite discussion topics. And I think it became more of a favorite of mine after my first appointment in 2014. And primarily this is because it is only then that I had a full appreciation, or just a taste, I shouldn't say full appreciation yet because it's ever evolving, of just how much of a challenge the strict application of that doctrine is in practical sense for the functioning of our constitutional democracy. And I'll try to explain. When I was first introduced to the doctrine so many moons ago while pursuing A-levels law, in my mind, what was created was this line, and I think the judge alluded to it, that there was this invisible line drawn between each arm of government that one or the other could not cross. The executive couldn't be a part of the legislature, the judiciary couldn't overstep its bounds and interfere, and vice versa. So there was this independence that I saw in my mind that could never overlap. And so it was a challenge to reconcile that with the reality of what operates in our legislature. And just by way of example, in the 2014, the elections that resulted in my appointment, we had the ruling party holding 14 of the 17 seats in the House of Representatives, while the opposition only held 3. Now, all 14 members, save for one, sat in the cabinet. They were appointed to cabinet, the executive arm of government. And the sole member, the only reason that he did not, and I'm speculating here not, that it may be other reasons, but the sole reason that was advanced was because the Constitution requires that the deputy speaker, that there be a deputy speaker, and that person must be an elected member and not a member of cabinet. And so the member became the choice for the backbencher on the government side. Now, this was very controversial because his constituents felt that he should have been a member of cabinet because of the significance of his victory. And so there was some issues arising, but eventually that settled down. And until the next elections, 2018, we saw a repeat again. In fact, the majority increased by 1, where the ruling government party holds 15 seats, and there are now 2 for the opposition parties. But a similar result, composition of the cabinet is the same, save for 1 elected person who now holds the backbencher position as deputy speaker, although it's a different person to the 2014 elections. Now, truthfully, outside of the results of these 2 elections, I grew up during a political history for most parts where there were very few members sitting on the opposition benches in the House of Representatives here. And I think I've been counted about 9 cycles since my birth. So you will know how long that is. And at one time, I actually thought that this was the most significant challenge to the doctrine of the separation of powers. How could the legislature effectively call out the executive, hold them accountable while they're functioning, when there's only 1 backbencher on the government side, or 2 or 3 opposition members. And in some instances, and we've had that in recent times in the region, where there are no members of the opposition in the House of Representatives. And we have Grenada in 2018 March and Barbados in 2018, where you saw 15, all of the seats in Grenada, 15 seats and 30 seats in Barbados going to the ruling government. I had a serious challenge reconciling this with the learning that I had of the separation of powers. What my appointment did and what the Latimer House principles did for me was to help me bring into focus. And I'm borrowing the words here of the Commonwealth Secretary General at the time, Kamlesh Sharma, who said, and you can find this in the foreword of the Latimer House principles, that the separation of powers may look well on paper and sound well in speeches, but every Commonwealth member must continuously pose itself the question, how well does it really observe the separation of powers? And I think just Judge Jacob dealt with this very clearly in his presentation. That is exactly how I felt. I felt that separation of powers was a static concept. It was not that it was not static, that it was just that it was static. As opposed to being as dynamic as it really is. And it took me a while to accept and embrace this. And for me, and I encouraged other members of the legislature who are part of this webinar, who have not been exposed as some of us might be to the principles, to look at it, because it really helped me to accept that this line that I saw as being blurred between the executive and the legislature would be a stumbling block for the effective application of separation of powers in our constitutional jurisdiction. But I've come to appreciate, and I think I'm settled, I could be wrong, that the blurred lines that I perceive did not necessarily signal the death of democracy. And I see that very much. And I hear the examples in other jurisdictions when they talk about the limitations on the judges, judiciary. And I cannot identify with that in Antigua and Barbuda. But for me, I asked myself the question, how could it be that the framers of our Constitution, who clearly envisioned that this overlap would have been a part of the functioning of our government, would have accepted by providing in our Constitution that the cabinet shall consist of the Prime Minister and such other number of persons or number of ministers whom the Prime Minister may consider appropriate. And of course, the ministers are appointed on the advice of the Prime Minister from members of the House of Representatives and the Senate. And so I believe there had to have been some reconciliation at that time of this principle. And I have come to use the Latimer principles to help me put this into perspective. And so in operationalizing the principles and seeing how it functions on a day-to-day, I have been able to assess a more effective functioning legislature in terms of its discharge of its functions and its roles and responsibilities under what we expect to happen and in the concept of preservation of the rule of law. And I asked myself the questions, what is our executive, what mechanisms we have in place to check on our executive? Is there opportunity for question time? Do we allow for the standing orders and the committees? And I must say that we have come quite a long way in effecting this. And I'm so the exposure to help me deal with that issue, because I now see that there is a system of checks and balances that can be developed and put in place depending on your individual situation, so that the lines that I saw or that we understand to be delineating those three arms of government do not get washed away completely at any time. So from my chair, the presiding officer's chair, since 2014, I've noticed a strengthening of the awareness of the members of the legislature, particularly of the Senate, of their role in reviewing and scrutinizing the proposals of the executive which come to them through the bills and the standing orders and resolutions. And I must say, the members of the opposition have caused our members on the government bench to be very vigilant and always aware of what they're presenting to the people, because they challenge them to give answers. One of the questions posed to us in the brief for this webinar relates to how do we keep governments accountable with respect to the emergency powers introduced during this pandemic? And it was interesting to hear Judge Jacob speak on this issue, touch on it barely. But I can say over the past year, we've been to Parliament on at least 5 occasions. Firstly, to invoke the emergency provisions under the Constitution, and every successive 3-month interval since then. I think we last went in March to extend that period because we could not see, as legislators, how we could put in place these provisions to curtail movement, constitutional vested rights, and to impose restrictions, and also to mandate that persons wear masks in public places along other protocols that were established by the Ministry of Health without having the teeth of Parliament. And that for us was very, very important. And so we used technology, we incorporated technology. At one time, we were not able to sit all members at the same time in the House. That was incorporated. And so this pandemic has brought us quite a number of challenges and quite a number of learning opportunities. And so we have, as I said, over the year, we've spent the Senate on each sitting on the emergency powers, we've spent at least 2 hours. I've also noticed an increase in public consultations. So bills are being sent to respective stakeholders, including our Bar Association, for their input and comments before or during select committee stage. And the use of the committees has become more commonplace in the legislative process than it was before. Notices are published in the press of the convening consultations or committee meetings at Parliament and interested civic organizations, and the general public are generally invited to attend these at Parliament. Citizen engagement is becoming a hallmark of our Parliament. And I say citizen engagement, not populism, and this is a challenge for us, and I believe it is a challenge for all of legislators, is to address the misinformation and the excitement and the irrationality, and I dare say, Judge Jacob, the indiscipline which populism brings to the dialogue, to the discourse. And of course, because of the misuse of IT, it's a wonderful tool, but there's a significant misuse that is brought into the existence of our modern parliaments, and that is a challenge. And we're looking to see how we can control this as much as possible. And I must say the government and the Honorable AG's team should be commended for the work that they've done in bringing us to this level in terms of the consultative process that is engaged now. We still have a challenge with timelines. That is the gap between the first, second, and third readings of the bills. In some instances, it's negligible, but it seemingly accompanies a parliamentary structure with the overwhelming majority when the ayes always have it. And it's something, as presiding officers, we've noted that is out of our control when the legislative agenda is also driven by the executive, unfortunately. The standing orders as well allows for waiver of that provision. So speed is not always effective, and it sometimes leads to amendments in quick succession of the passage of the act, which we've experienced, and challenges for constitutionality. I don't think that there's been any, and I could be wrong, if any, there might be one, but I do not think that there have been any challenges, especially during the time of the pandemic, to the constitutionality of legislation. And I also wish to say that if we look at the principles set out in guideline 6 of the Latimer principles, the executive's accountability to Parliament, the use of question time and committees that the Honourable Speaker, Sir Gerald Watton, and we were very instrumental in getting the standing orders updated in 2020 last year, and these have not been touched since 1967, and even that is even before independence. We became independent in 1981. So we've done a tremendous amount of work in trying to bring to the fore, within the context of the Latimer principles, those measures and mechanisms that are needed to hold the executive arm more accountable to the legislature. And we recognize that our efficiency is a continuous work in progress, and we, of course, will learn from our counterparts in the CPA, and we welcome any support as well. And as it relates, again, to the guideline, CPA, the Executive Accountability to Parliament, the non-functioning of Public Accounts Committee, I believe, and I submit, undermines the accountability process. And I'm aware that this is a challenge in a number of jurisdictions. And I'm hopeful that during the question time, we would be able to share the experiences within the region, within the Commonwealth countries, as to how others have guarded against this challenge. I believe our major challenge from the legislature's perspective remains, even pre-COVID, what I have summed everything up into one little package called autonomy, or the absence of it. On the principle set out in Guideline 7, the lawmaking process is expected to be serviced by professional staff independent of the regular public service, and should also have adequate resources to be able to discharge its parliamentary function and set its own budget, which should not be subject to amendment by the executive. Now, we are a long way from this, a long, long way. We did start the conversation with the Honorable Prime Minister prior to COVID, and of course, since COVID, that has been priority, and we hope that we'll be able to get back to that in short time. And so we rely on our partners like the CPA to provide auxiliary support in training our staff, and we hope that will also help position us as legislators to look and effect our roles as legislators more effectively with the view of preserving this separation, the independence of the legislature. We know too that in for me, I think in the post-pandemic Antigua and Barbuda, the strengthening of the rule of law is what I'm expected. The precepts are rudimentary to our democracy, and I think the structure as it operates, especially from the perspective of challenge and using the courts to challenge the actions of the legislature, has been very robust, even actions of the executive. And I don't expect that it will be curtailed at all at any time soon. In fact, I think it would be strengthened. And if you look at how we have used the emergency powers under the Constitution to do this, to bring about the structure and the discipline that was needed during the pandemic, we realize that persons are very acutely aware of their rights and the delicate balance that has to be maintained between the trampling of those private rights and the overarching interests of the general public. And it is also very important that we remain vigilant in helping the people to understand that they have a role to play. In just a few more points that I need to make before I close, the questions that ask, what can organizations such as the CPA and CLA do to ensure the Latimer principles are upheld? To my mind, the COVID pandemic has afforded us a timely reminder of the importance of maintaining connections. And technology has proven just how pivotal it is a survival tool in these modern times in doing just that. As we are doing today, networking, the way to do business, has taken on a new phase. So these webinars, these seminars, these interactive sessions that facilitate outreach, I believe should be a critical tool that the CPA would use in connecting with not just us as lawyers and legislators, but the general populace. I think it's an opportunity to reach out to youth groups, an opportunity to reach out to non-governmental organizations. And just recently, the presiding officers were talking about, they were sharing their experiences in terms of what they have used to engage the general public, especially the youth, because continuity and succession are very important. And if they are not understanding as to what it is the Latimer principles are about, how do they look to ensure that there's accountability from every tier of government? So that is, I think, very important that we look at going forward in terms of championing the rule of law for the citizens of our countries. Now, I'm almost closing. It's my last statement. I wish to just highlight that in Guideline 4, the role of women in Parliament is still very critical. We only have 2 out of 17 in the House of Representatives, although we have a majority in the Senate. And coming out of this pandemic, I pray that the marginalization of our women is not lost in it, and also that in our quest to have them re-employed, because they have been one of the casualties of major casualties of this pandemic, that we don't lose sight of that empowerment opportunities at all. In closing, I wish to state that firmly I believe the rule of law is well preserved and protected in our robust parliamentary democracies here in Antigua, and by extension, other members of the Caribbean region. There's always an opportunity for enhancing the machinery, and that is why dialogue and conversations like these are necessary. The strict application of the separation of powers, as I said, does not demonstrate a pragmatic way of allowing for the preservation and checks and balances that we need. But what I submit is important is a continuous education of our citizenry that will allow them to challenge and cause their representatives and other parliamentarians to challenge any policy or anyone who seeks to uproot those protections. And the CPA and the CLA as well have a critical role in playing in this environmental of awareness. Thank you very much for the opportunity again, and thank you for sharing.
Thank you, Senator. It's quite a challenge, isn't it, to balance these competing threads, to remain disciplined. But I think you drew out very effectively that actually, whether it is lawyers or judges or parliamentarians, there is a role of serving and meeting the needs of the people, and maintaining discipline and maintaining that function, such as you've described about recognizing the dynamic nature of our world and our lives. I'm very attracted, coming from a small jurisdiction part of the United Kingdom. I'm always attracted by the smaller jurisdictions in the Commonwealth and how they navigate through the requirements of democracy in the absence of an official opposition. And I think that your particular jurisdiction is well served by you, Senator, by recognizing that and by giving such precedence to the Latimer House principles, which some members of other organizations who were participants in drawing them up, I know are listening in, and we will be very pleased to seek to advance knowledge of those principles and seek to provide support the founding members, the CPA, the CLA, the Commonwealth Magistrates and Judges, and the Legal Education Association would love to assist further, and will certainly like to have heard the Latimer House principles so eloquently described, Senator. Thank you for those remarks. Now we have time to deal with our last contributor before Emily tries to collate the comments and the questions. And we now head to Oyo State, Nigeria, where a practitioner colleague, Oluseun Abimbola, is present. And Oluseun is a senior lawyer in prime solicitors in Ibadan, Oyo State, working in commercial law and telecoms and media, an arbitrator and mediator. He is a leader of his profession, a senior advocate of Nigeria. He is currently the chair of the section of legal practice for the very influential and numerous Nigerian Bar Association. I was sorry I wasn't able to travel to your conference marking the 60th anniversary of independence, which normally would attract about 10,000 or more lawyers, but I did take part in some opening remarks. You also served, Olusegun, as the Attorney General for Oyo State, and we look forward now to your comments on our theme of lawyers, parliamentarians, and the rule of law. Over to you.
Thank you very much, Brian, and I appreciate your invitation to speak and be part of this conversation. I appreciate the CPA and the CLA for this organization as well. Lawyers, parliamentarians, and the rule of law. There is no doubt that those three issues occupy a very important role in any democracy. I think it was Roscoe Pound that described law as an instrument of social engineering, and either in the hand of the lawyer or of the legislator who passes the law or the judicial officer who interprets the law, there must be a paramount consideration as to the purpose for which we're implementing the instrumentality of law to achieve, whether it's to deal with whatever mischief or to expand boundaries. Now, we can speak of governments dispassionately, and it will sometimes sound like an inanimate, abstract, self-driving machine that runs the show on behalf of the people. But in the reality, governments are run by men. And to that extent, it is the will, the choices, the decisions of those men that run government, whether on the executive or the legislature or the judiciary, that gets impacted in the legislative process, in the judicial process sometimes, and then also even in the executive. And I'm coming back to say a few things with respect to that. I think our greatest challenge in Africa, in Nigeria, and of course in some of the other continents as well, has always been with the operators of the constitutions, operators of the laws. For instance, if you're going to consider some of those challenges that we have experienced in Nigeria, and this is not peculiar to Nigeria, you will talk about the problem of the politics of power. Whenever we look at the separation of powers, the Latimer House principles, our constitutions have incorporated these principles to a very large extent, and that should presuppose the natural application of those principles of the rule of law to all our facets of engagement, whether as members of the executive or the legislature. But then the politics of power has crept into the governance systems in many parts of the world, in Nigeria inclusive, to such an extent that it is not uncommon to have elected representatives, whether on the executive or the legislature. You have elected representatives, government officials, sacrifice their own independence and the independence of their own arm of government on the altar of politics. And so when you have an institution that is meant to serve as a check to another institution, and one institution has mortgaged its own powers on the altar of politics, either because we're of the same political party and all of that, then you realize that when you speak of the separation of powers, some of the operators themselves become the instruments that breach that doctrine of separation of powers. Again, it is also not uncommon to find, and again, I say this is not peculiar to Africa, it's even in the developed world, you see this happen almost fairly regularly. It throws the entire polity into disarray just for political interest. And that has impacted both the quality of legislation, sometimes in the legislative house. It has impacted projects that the executive will implement and the manner of implementation. It has impacted appointments into positions in government. And one of the Latimer House principles deals with public office holders and emphasizes, for instance, the principle of merit, emphasizes the principle of proven integrity to be the paramount criteria or eligibility for appointment into public office. But when you have appointments take place into public office, and some of those appointments are actually subject to ratification or approval of a Senate or approval of some other arm of the legislature, and yet breach the established principles of merit, of integrity, of fairness, and of fair representation, then you know that it is the institution itself that has breached its own, the principles that it ought to uphold. You also have to deal with another challenge. We deal with the problem of, let me call it the separation of power itself. Knowing that in the looking at the limits of what separation of power itself might offer different institutions, we can see that, for instance, the different arms of government, executive and legislature, you see increasingly in recent times an attempt to expand or test the limits of their powers. And this is reflected in the increasing use of executive orders. And this, again, is not limited to one country or the other. There is an increasing use of executive orders in recent times than it ever was in the history of executive orders across the globe. And that itself speaks to perhaps 2 or 3 different issues. One, the need for the executive to carry out its objectives, its goals, and to stifle, so to speak, opposition that might come from another institution that is merely exercising its own powers. Secondly, you also have it happen in situations where executive orders are passed basically to avoid or to circumvent the legislative process. And of course, members of the executive have also argued back to say that sometimes executive orders become necessary simply because the legislature in their country has probably become a bit put itself in a position of, either by virtue of politics of power also, or for many other reasons, that it becomes a hindrance to the carrying out of the objectives of government. And so for whatever reasons, right or wrong, we find out that there is an increasing dependence on the use of executive orders. And some of them naturally will be challenged in court, and the judiciary gets to interpret whether this executive order is an encroachment on legislative powers or otherwise. On the side of the legislature, we're also contending with situations when the legislature itself purports to exercise judicial powers. Sometimes members of the legislature, maybe some specialized committee or even the General Assembly, might move motions, pass resolutions, which they assume have the same force or effect as an order that can be enforced by a court of law. And you see the narrative that is put out there by some of these legislative houses that seeks to transform their resolutions and their motions into enforceable orders like a court judgment. Again, lawyers have to play the role of challenging some of these excesses so that we can keep within the boundaries or the limits that our constitutions, that our powers are circumscribed as executive or as legislature. There is an ongoing controversy, or let me put it this way, conversation about the autonomy issue. The autonomy question is an ongoing issue in Nigeria, for instance, both with legislative autonomy and judicial autonomy. one of such, it didn't start recently, but one of the things that has aided its implementation is the fact that it was challenged in court by a lawyer, indeed by former president of the Bar Association, that the autonomy provision of the Constitution must be enforced. And the courts decided it, but then to find it implemented across the whole country has remained a challenge. And I asked myself the question, if a breach of the Constitution is an impeachable offense, how come no legislative house has raised a motion in any state? And it's not for the fact that they feel they don't have the powers. These are the issues that stifle the full expression of separation of powers. When you have the power to check the other arm of government and you fail to use it. And then it only gets used when the politics of the day dictates it to be used. If, for instance, the politics of the day changes, then you see a lot more activity, as it were, to keep executives in check. But when the politics of the day seems to be favorable to both houses, then you don't see any expression of authority or an attempt to curtail the excess of one arm by the other. Another thing that has blurred.
Ole, so I'm going to have to, because we have a sort of finishing point, and I know that Emily needs to come in with questions. Yes. Would you mind awfully if I just paused you there? It's raised a very fascinating point about the willingness to be constrained, as you call it, the operators of the Constitution, the women and men in Parliament who deal with the day-to-day operations of decision-making, and the interface and implementation of challenges to uphold the Constitution. So I think, Emily, I would like to make time, and I appreciate, Oluseun, the perspective from Nigeria, a very large democracy, in contrast with some of the smaller jurisdictions that are represented. And there have been questions, there has been chat. Emily, would you mind trying to summarize or to bring forward some of the questions and to bring back in our panelists from earlier? If I could invite you to do that now. Thank you.
Absolutely. Thank you very much, Brian, and thank you again to our three speakers. So thanks everyone for sending in the questions. We've had a lot, so I'll take the first three all together and then pose them to our panelists. So the first question follows on, I think, from what the Senator Williams-Grant was touching upon. To what extent, in all three of your jurisdictions, is the membership of parliamentary committees of the Representative Assembly controlled by members of the executive? And if the executive has significant influence or control over the membership, does that undermine executive accountability? The second question is regarding the press. So how can we convince the press and social media users that differences of opinion are inevitable and have to be accepted on all sides? And can anything be done to lower the heat of public debate on controversial issues? And then the third question that we'll take in this round, given the perilous times in challenges to the rule of law, what's your response where government-employed lawyers acquiesce the actions of their employers when it's perhaps detrimental to the rule of law? How can a lawyer strike a balance in upholding the rule of law whilst also serving the directions of an employer when that's a government? And I know that there were three quite lengthy questions, so do let me know if you need anything repeated. Perhaps if we go first to Judge Yakub, and feel free to pick up on any three of the questions. I know that we're a bit tight for time now in terms of answering them all.
So short answers, I think, Emily, is what we're looking for to those three interesting questions.
Okay, I think I'm unmuted.
Yes.
As far as the first question is concerned, our country has a particular problem, which I think most countries have, including England, in relation to the separation of powers. Now, I'll do this as quickly as I can. We have a proportional electoral system, and the African National Congress is at the moment in power with a vote of about 55, 56%. and 55–56% of the parliamentarians. Parliament elects the president, but the problem is that the majority of parliamentarians are ANC people. So in effect, the ANC elects the president of the country, and in effect, ultimately, the boss of the African National Congress is also the boss of the executive ultimately. Now, parliamentarians have a duty to exact accountability from the executive, but this fails because there's a conflict between party loyalty and loyalty to the Constitution. So they are party whips, and ANC members swear loyalty to the political party. On the other hand, they take an oath to adhere to the Constitution. And there's a difference between allegiance to the Constitution and allegiance to a political party, and there's not yet been a case to resolve it. But in practice, what this means is that Parliament will, however, bring the executive to account, because you need a certain number of votes in a democracy to bring the executive into account, because the chief whip decides how ANC members vote in an election, and the ANC ultimately makes that decision, and the ANC decision will generally be in favor of itself, namely in favor of the president. So that is one weakness. So we've looked at the separation of powers insofar as the judiciary and Parliament is concerned to a degree, but Parliament and the executive, I suspect that precisely the same problem exists in many democracies where members have to choose between adhering to their oath to obey the law and the Constitution where there is a Constitution, and sticking to political parties. The second question, very briefly, is the heat in relation to public opinion. I must say, on the one hand, that heat is to a degree important, but it is a question of leadership and how that heat is controlled. The problem, again, is that opportunism by leadership means that that heat is increased considerably regardless of the result. With the result that in our country, for example, protests are deliberately brought about to ensure that political power is increased, and things are supported like violence during protest action and so on, which should not be supported. And therefore, again, the discipline of leadership is important, and that heat cannot be controlled by people themselves. It is a duty of leadership to do so. And I would imagine that the leadership in most countries fails that test. I'll stop there.
Thank you very much, Judge Yakub. Senator Williams-Grant, if I could pose those three questions to you now. Thank you.
And thank you, Emily. I'm going to start with Honorable Judge ended. When the question was posed, I said, why would we want to stop the heat? Why would we want to, but it can get to a point where it becomes overwhelmingly aggressive. And what we've found is it's almost similar to what the judge explained in terms of the executive and the legislature, that relationship that is cut along party lines. You now have parties who are fanning the flame, as you would say, to have a political position advanced, and so they encourage the dialogue, and it gets heated along those lines. And so it's a more call on us all to be disciplined, and remembering that it's not just, I know the honorable member from Nigeria mentioned that it's not the people that are in government, but the men. And that is the challenge, that we get caught up in the egos, and trying to retain the politics of power becomes the order of the day, as opposed to all these principles that we see, we know, we understand, and we should be advancing. But politics of and the power becomes paramount. And I guess it's a continuous balancing act. I don't have an answer to that, but I think the robust discussion, the dialogue is important, and it helps us to be kept in check. I'm going to deal with the question about government employed lawyers. Is, as I say to anybody working anywhere, If you are uncomfortable with a decision that you're called to make, you know what you have to do. And I think it translates whether you are an elected official, appointed official, or a paid person. If you are uncomfortable, you find it violates your ethics, your moral standards, you walk. You know, I know insofar as whistleblowing and the protections afforded there, I'm not sure what the legislative provision would be in that person's jurisdiction, but it's something to consider. But for me, if I'm uncomfortable and it gets too much, I would definitely leave. Insofar as the composition of the executives, the committees is concerned, then it is based on our structure. Clearly, if our constitution says that the executive is able, the legislature, members of the legislature is able to sit in the executive. When it comes to the committee stages, you will find that it's a mix, a blend. The only delineation we've drawn is that the Senate, unless it's a joint committee, the Senate does not sit in committees of the lower house. But obviously, if it is that the committee, the lower house has established a special committee, for instance, members of the executive would sit in that. And again, along the policy lines of the government, I would imagine decisions are taken. Thank you.
Thank you very much, Senator. And Mr. Abimbola, if I could bring you in. Thank you. Oh, I think you're on mute still.
Yes, thank you. I think the point made by George Yacobi is apt with respect to what is experienced in most countries, party loyalty against loyalty to the Constitution. And in most cases, what we have seen is an inching towards party loyalty rather than towards upholding their constitutional responsibilities among legislators in checking the executive. And until we get to the point where legislature, that's why some people have canvassed in Nigeria, for instance, that the role of members of the National Assembly should be taken as a part-time job rather than a full-time job. When it's taken as a part-time job, it means your primary obligations remain your day job. And so there's no pressure on you to remain there and do the bidding of the executive just to assure your continuity of office because you've got something else to do. And that also applies to every appointee in government, at least political appointee. The third question on lawyers who are advisors to the government. If, for instance, I served as an attorney general, it was a political appointment. It was not a permanent appointment. So in my role as attorney general, I came from private legal practice. Courage will always be required of any political office holder. Discipline will always be required of any political office holder. And of course, competence. Because there will be hard decisions to be taken, and you must be able to stand by it. There will be difficult choices to be made, and you must be able to defend it. And if you have to give an advice to your appointor or your employer, and it is rejected, of course, as the senator said, you should know what next to do if you want to, one, at least maintain your integrity, save your own name from being muddled up with wrongdoing, and also be able to ensure that the system is sustained with respect to observing the separation of powers. As for what the press and social media, the aggression we see, particularly in social media now, I think it's just a reflection of the signs of the times. The liberty that people have to express themselves without having to write a column in a newspaper, without them having to disclose their names, particularly in countries where freedom of expression, freedom of the press is still a bit of a challenge. Social media offers an alternative route to make your comments and make your opinions heard. But then, of course, with everything, there will always be abuse. And so there will have to be some measure of regulation, but there will always be suspicion when regulation is tossed at social media because of free speech. And that's the kind of challenge we've also experienced when the National Assembly proposed the social media bill to regulate, because then you ask yourself, how far will this regulation go before it enters into the purview of limiting of your freedom of speech?
Thank you very much, Mr. Abimbola. So unfortunately, we don't have any more time for any more questions, but thank you to everyone who sent one in. And I'm sure, Brian, we can field the questions to our speakers if anyone wants to send any additional ones via email. I'm sure all of our attendees will join me in thanking our three excellent speakers. Thank you so much for taking the time to present to us today. And I think we had a great discussion. And thank you also to Brian and the CLA for co-hosting this event with us. As you said, it's the first CLA CPA event, but hopefully not the last.
Not the last, Emily, not at all.
It's been a really interesting deep dive into the roles of parliamentarians and those in the legal profession and how their remits and responsibilities interact. We've spoken about the dynamism of the rule of law, the importance of checks and balances, and obviously the importance of upholding the Latimer House principles. So thank you to our speakers again, to Brian and to all of our attendees, and we look forward to seeing you at a future event soon. Thank you.
Thank you, Emily.
Thank you.